Okay, welcome everybody. It's been a while since I've had you in my class. I hope you've all been keeping well. Starting today with the last part of the work that we need to do. Semester is winding down. We still need to look at partnerships. Partnerships forms quite a large part of your syllabus. It's also very important, both for practical reasons. You're studying accounting. Maybe one day you're going to be entering into a partnership to practice as accountants, or even with your accounting background, become an entrepreneur, start a business with some partners as a partnership. So for practical reasons, it's also important for you to know and understand the law underlying partnerships. Partnerships have some very far-reaching consequences, which you will pick up on as we go along with the class. We're scheduled to do Unit 12 this week, and then next week we have a revision week. Unit 12 is a lengthy unit. It's nearly 10 pages, so I'm not going to try to finish everything today. I will then finish the rest on Monday. Giving you advance warning that on Wednesday we will not have class because the commercial law 1A students are writing a face-to-face test. I have to go and assist the test. And then on Saturday, you're doing test 2. Test 2 is online, so it's open book. Past experience has taught that students normally do better in the online tests than in the face-to-face tests for various reasons. One of the reasons being the fact that it is open book. It's not just multiple choice, it consists of a variety of different questions. However, there are no essay questions. There's nothing you have to type, but it's a missing word and short questions, blah, 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 blah. You've all done my, no, actually you haven't. This is the first time you're in my class. Questions come from a question bank. So everybody does, you all get different questions and different sequence. So you can't sit with your friends and try to work out the test together. Okay, having said that, let's move on then to partnerships. Now, let me just share my screen. Sorry, my laptop is a little bit slow this morning. Okay, just give me a thumbs up if you could see the screen. Thumbs up, somebody, please, if you could see the screen. Thank you, Benjamin, Shikupe. Okay, so now you might be wondering, why is partnerships part of Introduction to Law for Accountants? So far, we've been talking about contracts. We started off with contracts in general, and then we've been looking at some specific types of contracts, purchase and sale, lease agreements, and we learned that every specific type of contract has its own consequences, natural legal consequences, rights and duties that arise from this contract that apply specifically to contracts of this type. Now, you're also accounting students, so I'm sure you've come across the concept, the term partnership. And I won't blame you for thinking that a partnership is a type of business. And then consequently asking, but we've been talking all about contracts so far. Why now suddenly this jump to looking at a type of business? What you might not realize is that a partnership is just also, like purchase and sale, like lease agreements, another type of contract that comes with its own legal consequences that are inherent to partnerships unless they have been changed especially between their partners. But we also learn that there are some consequences which you cannot change. You can change them internally, but not with regard to third parties. Can have some quite far-reaching consequences that you need to be aware of. Bottom line is, if you're going into a partnership one day, choose your partners carefully. Okay, so let's start off. Give me a second. Just want to open another file on my laptop as well. By the way, people, I don't think I've mentioned this, but at the beginning of the study unit, there is a list of learning outcomes. Upon completion of this unit, you should be able to, and then a whole list of various learning outcomes. Don't just skip over these learning outcomes. Once you've worked through the study unit, go back and test yourself against these learning outcomes and see whether you have actually attained them. If you've attained them, it means that you have mastered and grasped the actual study unit. So let's start off by finding out what is a partnership. Definition there. It's just one of various definitions, but this is the one. They all boil down to roughly the same thing. A partnership is a legal relationship arising from a contract between two or more, usually not exceeding 20 persons. In terms of this agreement, each person must undertake to contribute towards an enterprise carried on in common with the object of making and sharing profits. So the first important thing here that you get away from this definition, which then clarifies why partnerships form part of Introduction to Law for Accountants, is that a partnership legal relationship arising from a contract. So this should immediately alert you to the fact that whatever you learned so far about contracts, 5 requirements for a valid contract, breach of contract, etc., etc., also applies to partnerships. Always remember that a partnership is a legal relationship arising from a contract. Now, when we did purchase and sale, we looked at the essential elements that must be in this contract in order for it to be classified as purchase and sale. Same thing with a partnership. It's a contract, but what makes this contract a partnership? What are the requirements? So first of all, obviously, and we're going to get back to this, at some stage. First of all, the contract must be valid. 5 requirements for a valid contract. People with no contractual capacity cannot enter into a partnership. Performance must be legal. You cannot enter into a partnership in order to sell drugs because performance would be illegal. So that would not be a valid partnership because the contract itself is not valid. So first of all, there must be a valid contract. One peculiar aspect that I will be getting back to in a while. Secondly, in order for this valid contract to be a partnership, the requirements are, I'm going to put that one separately, I'm not going to number it. Your requirements are each partner must contribute. There must be business for the joint benefit of the partners, and the object of this business must be to make and share a profit. So in order for it to be a partnership, there must be 3 things agreed upon in this valid contract, namely each partner must contribute, there must be a business for the joint benefit of the partners, and the object must be to make and share a profit. If you look at the definition of a partnership, it actually contains these 3 elements. So if you know the definition, you will have the 3 requirements. Each person must undertake to contribute. Each partner must contribute towards an enterprise carried on in common. Joint benefit of the parties with the object of making and sharing profits. Object to make and share a profit. So the definition and the definition actually contains these requirements. So now we're going to just have, no, okay, we'll do that later. Sorry. The legal nature of a partnership. What do I mean by this? And this is very, very important also for actual real life purposes. A partnership is not a thing. It is a legal relationship arising from a contract, which means it is not a separate entity. It is a contractual association of partners. And very importantly, it is not a juristic person. So it is not an entity that exists outside of the partners. Companies, for example, companies and close corporations. Next semester, we're going to be doing company law together. A company is an entity that has its own independent existence. Partnerships don't exist outside of partners. We're going to be getting back to this quite regularly. It's not a juristic person. It's not an entity. Doesn't exist on its own. And an important consequence of this is that the partners can ultimately be held liable for the debts of the business, the debts of the partnership. Going to get back to this consequence. A number of times. This is far-reaching. Let me give you an illustration here. If Benjamin and Shikupe start a business together in the form of a partnership, but they've each got their own private assets as well. Benjamin owns a farm. Shikupe has a house and a car, which are separate from their business. But an important consequence of the law of partnerships is if this business goes pear-shaped and the business ends up owing Rocher 7 bags of money, Rocher can take the necessary legal action and claim the money from Benjamin or from Shikupe or from both. And Benjamin might end up having to sell his farm in order to cover the debts that were incurred in the business. Lots of red lights there. So be careful once you start going into partnerships, because ultimately the partners are liable for the debts of the business. It is not a juristic person. Important legal concept that I have to teach you here, which we're going to be coming across also when we do the law of company law at a later stage, is the concept of joint and several liability. So partners are liable for the debts of the business. During the existence, so while the partnership still exists, partners are jointly liable. So if Shikupe, if the business still exists and Rocher wants to recover the money they owe her, she has to take action against Benjamin and Shikupe together and be liable for the debts according to their agreed ratios in their partnership agreement. We'll get to that. But an important consequence arises once the partnership has dissolved. So after it's come to an end, After dissolution of the partnership, and severally liable. The concept of joint and several liability is not a partnership contract. It's not unique to partnerships. You have joint and several liability also in some instances in companies, etc., etc. It's a general legal concept. What does joint and several liability mean? Joint together and several apart. It means a creditor can recover their debt from all the partners or from just one or more of the partners. So in our example, Benjamin and Chikupe were in a partnership. Let's say Benjamin comes from a wealthy family. He's inherited the family farm. He is independently wealthy outside the business. Chikupe, on the other hand, not so much. Now the business goes pear-shaped and they still own Ruche 7 bags of money and she wants to recover her money. Business has dissolved, partnership has dissolved. Benjamin and Chikupe become jointly and severally liable. Because of joint and several liability, Ruche can choose whether she wants to take them both to court together or just one or more of them. She has the right to recover the full outstanding debt from Benjamin. And he will have to pay everything he's still owed to Ruche. He then has the right to try to recover a share from Chikupe. But if she doesn't have it, she doesn't have it. What's happening here? Is going to get all her money because Benjamin has to pay everything. But if Benjamin Chikupe might not be able to recover his share. So in fact, he's paying share, losing out. Very, very far-reaching consequence, joint several liability. Please understand and remember this concept. So, just to recap, partnership does not have legal personality. It's not a juristic person. Does not have legal personality. Partners are liable for the debt of the business. There are some exceptions, some statutory exceptions where a partnership is treated as an entity. These are listed on page 70 of your study notes. For example, the rules of the High Court, I'm not going to type them out. Rules of the High Court and Magistrates Court provide that a partnership may sue and be sued in the name of partnership. So if while business is still existing, Ruche will not, when she goes to court, she will not issue summons against Benjamin and Chikupe. She will issue summons against B and S partnership, for example. So for court proceedings, under certain circumstances, they are regarded as an entity. To the rules of court, creditor, we will get back to this later, who has obtained judgment, must first act against the partnership fund before attaching private property. So it's only if there was nothing left in the business that Roche can run after Benjamin's farm. And also there's an effect on insolvency proceedings. Just have a look at those exceptions. We don't dwell on them too much. Any questions so far? No questions. Okay, let's move on and look at the partnership agreement. I need to warn you people, there's a lot of repetition in partnerships while we're studying. So it's as if we start off with a skeleton with a bare bones, and then we keep on adding more flesh, and then we start putting clothes on. A lot of repetition. Start seeing these repetitions. I don't think every page is different information. Notice where everything fits together. So, partnership agreement. We've seen it's a legal relationship arising from a contract. Look at this contract. It must be a valid contract. Now, think so. All the 5 requirements. This you might find strange because you tend to think of a partnership as a big, important business. Let's use an example here. Let's say, let's use different people for a change. Nashita, Sophia, and Victor decide they want to go away together for a weekend. They take a break before the exams and go and spend the weekend in Swakopmund to relax. But they're all a little bit strapped for cash. So they decide to earn some money in order to fund their trip. And they decide a good business idea is always hungry students on campus. They're going to start selling sandwiches. So they each chip in $100. Walked out to Vernil Mall, buy some bread, margarine, cheese, jam, whatever they want to put on these sandwiches. They go to Nashita's room, they make sandwiches, put them in nice little bags. Off they go to campus, walk different directions. They're not walking together, walking different directions, different parts of campus. They sell these sandwiches. And when they've sold out their sandwiches, they get together again. They put all their money together and see, do they now have they made enough money to be able to fund their trip to go to Swakopmund? Is that a partnership? Somebody. Sophia, Victor, and Nashita have put money together in order to make more money that they divide among themselves. Is that a partnership? Like, I only have silence to have no contribution. Sophia, Victor, and Nashita were in a partnership. What they did, putting money together, making sandwiches, selling sandwiches in order to make money to share between them, meets the requirements of a partnership. They were in a valid partnership that has all the legal consequences of a family partnership that was started with a 20-page contract drawn up by a lawyer. What happened? They contributed. They each threw in $100 to buy the ingredients. They worked together to make the sandwiches. They sold them. They contributed. They all worked together. There was a joint benefit for them. And their intention was to make and share a profit. They informally sold sandwiches on campus. They had a partnership. A partnership has got no prescribed formalities, does not have to be a long, complicated document. Obviously, if it's a bigger business, if you're intending to go into a partnership to practice together, accountants or whatever, I would not recommend you do it informally. I would recommend you go and see a lawyer to draw up a formal partnership agreement for you. But it is not a legal requirement. Must be possible. You can't form a partnership to go and mine down on the moon. It must be legal. You can't form a partnership to sell drugs. All the requirements for a valid contract. There's statutory provision that can affect the legality of the lawfulness of a partnership, namely Section 35, subsection 1 of the Companies Act. Section 30, you just need to remember it's the Companies Act. You don't need to memorize the section number. But Section 35(1) of the Companies Act provides that if a group of more than 20 persons want to do a business together with the aim of making a profit, they should register a company. To make a profit, to make a profit is important. I'm going to get back to that. More than 20 persons who want to do business to make a profit, they must register a company. Which brings us to my definition, where I said usually not exceeding 20. That comes from the Companies Act. Companies Act says if you are more than 20, you cannot practice legally as a partner. You have to register a company. There's an exception. That's why I said usually not more than 20. Section 35(2). Section 35, subsection 2 is that the Minister of Trade and Industry may exempt certain professions from the maximum number. In America, this is primarily legal practitioners, lawyers, and accountants, for example, that have been. So it's not a specific law firm, it's the entire profession which has applied and been granted an exemption. So you can have a partnership of legal practitioners that consists of more than 20 partners, or a partnership of accountants that can exist of more than 20 partners. You cannot, however, have a partnership that sells shoes that exists of more than 20 partners. Hence, what I said there, usually not existing 20, there are certain exemptions. Important here, Section 35(1) says, who want to do business to make a profit must register. It specifies to make a profit. So with other words, if it is a charitable organization, people working together to raise money for charity, Section 35 does not apply. So you can have a charitable organization existing of more than 20 members. Any questions? You're very quiet today. Okay, let's look at these requirements. As we saw when we were doing purchase and sale, there must be a thing sold, but there were requirements for something to qualify as a thing. Similarly, with these requirements, let's have a more in-depth. Look. Starting with the contribution. For those of you that have made the effort to attend the class, or that will subsequently be listening to the recording of the class, an examination hint. We'll have a class discussing the exam towards the end of the semester, but I'm telling you this now, an examination hint. There is literally a question in the first opportunity exam requiring you to discuss the essential elements of a partnership. So the part of the work that I'm going to be doing now until the end of our class. So let's look then at contribution. What do we mean by contribution? Each partner must contribute. It can be anything. That has commercial value. So it doesn't have to be just money. It can be anything. It can be goods. It can be money. Can be goods. But it can also be service. It can also be service. It can also be goods. It can be money. It can be goods. But it can also be service. But it can also be service. But it can also be goods. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it can also be service. But it can also be goods. But it Your time has got value. Who were my three partners? Sophia, Victor, and Shikupe. They wanted to raise money to go on holiday together. Let's say that at that stage, Shikupe was a little bit broke. She didn't have $100 to throw in. Instead, Sophia and Victor bought the bread and the cheese and everything, and Shikupe took this and made the sandwiches. That is, she also contributed because her time, her effort also has commercial value. What I've just illustrated here is your contribution does not have to be the same. Each partner can contribute something different. Does not have to have equal value. Something you need to remember while we're studying partnerships. I've come across quite often. This is going to arise again. Remember that a partnership agreement, as opposed to an employment agreement, if an employer offers somebody a job, I've offered Rocher a job. When we negotiate our employment relationship, we are not negotiating on equal footing because I'm the boss, she's desperate for the job. With a partnership arises from partners that negotiate on equal footing. Persons with contractual capacity that negotiate as equals. Go back here. Once again, a partnership is a legal relationship arising from a contract, an agreement. So, if Benjamin, Sophia, and Shikupe agree together that this is what they can do, Victor puts in $500. Sophia puts in $100, and Shikupe makes the sandwiches. Don't say, but it's not fair. Don't ever say anything with regard to partnerships, but it's not fair, because you agreed on it. If you felt that, no, me putting in 500 and Sophia only putting in 100 isn't fair, then don't go into this partnership. Nobody's forcing you to go into this partnership. But what you've agreed, then you have agreed to do it this way. So contributions don't have to be the same. They don't have to be of equal value. As long as everybody has agreed that this is okay for their particular partnership. Whatever you agree upon, as long as it's not illegal, your agreement. So it doesn't have to be the same, does not have to be the equal value. Anything movable goods, immovable property, when it comes to distributing goods, you can have either You can contribute either the ownership or just the use of the property. All might be vague at the moment. As we go on with partnerships, it become a lot more clear. So let's say, just to illustrate, you're going into a partnership and you need a delivery vehicle. And let's say Nathan is also one of our partnerships, and Nathan's contribution is that the partnership is his car. Important consequence. Type this out before I carry on with my explanation. The default rule is that ownership is contributed if you contribute the use only. It must be expressly specified. This is important. Let me tell you why. Because when the partnership dissolves, when it comes to an end, I'm going to do this in more detail. I need to explain this now. When a partnership comes to an end, what happens is that all the debts are paid, and whatever is there still left in the partnership fund is divided amongst the partners according to shares are agreed when the partnership starts. So Nathan, when you contribute your car, the default rule is that that car will become the property of the partnership, which means the partnership dissolves. That car, or the value of that car, will be shared with the other partners, with Shikupe, Sophia, and Victor. They have a claim on the car. It's no longer your car. It is now the partnership's car. Unless when you entered into this partnership, the agreement was that you will be contributing not the ownership, but the use of the car. You can't turn around in 6 months or a year's time when the partnership is dissolving and say, oh, no, give it back to me. This has to be agreed at the beginning of the partnership. Otherwise, you're going to find yourself without a car. As I said, partnerships have got far-reaching and important consequences that you have to be agreed on. Also, contribution must be at the risk of the partnership. Which means you've contributed $500,000 and the business has gone pear-shaped. You can't, you can't insist on getting them repay your $500,000. If it's lost, it's lost. You've lost it. The contribution must be at the risk of the partnership. If a person contributes, wants their money back, person who claims to contribute, I'm going to put contributes here in some nice inverted commas for us, a person who contributes but insists that their contribution must be repaid is not a partnership, is not a partner. If you say, okay, I'll put in $500,000, but at the end of the business, when the business develops, I want my 500,000 back. You are not a partner. You are a creditor. You have, in fact, only lent that money to the business. It is not a contribution. Joint benefit of the partners. What does that mean? Basically, it boils down to that you must work together. That does not mean that every partner must work together. The business must be in the common interest. That doesn't mean you have to do everything identical. It's fine. It is 100% fine for Sophia to make sandwiches and for Victor to go out and sell them. Because, so by joint business, that means you must all make the sandwiches together and you must all sell them together. It's fine for Sophia to make the sandwiches and for Victor to go out and sell them because you are contributing towards a common goal. And this common goal is ultimately to make a profit. That will be shared. On the other hand, if one person is making the decisions, and the others merely follow instructions, this is not a partnership. This then, if one person is making the decisions and the others are merely following instructions and don't have any input in these decisions, it is rather an employment relationship or something else. It does not have to be continuous. If you're going into a partnership to practice as accountant, the intention is to do this for an extended period of time. But it can be for a single transaction. My friends that I've used as example, who were they? Victor, Sophia, and Shakupe. They only wanted to sell these. They want to go on holiday once. This is a once-off thing. Once they've made their money and gone on their holiday, their partnership is over. They don't have to be bound to each other and continue selling sandwiches for the next 5 years. It can be for a single purpose or a single transaction. Once again, as long as they were all working together. Each party should be engaged as a principal and not merely an employee. With regard to management decisions that can be altered between the parties, we will get back to that at a later stage. And then the object to make a profit. It's a bit of an overlap between those two requirements. Business for the joint benefit per se implies that you're doing it in order to benefit, to make and share a profit. Fact that the object to make, so if Benjamin, Sophia and Shikupe were selling sandwiches in order to raise money for the Nust Hockey Club, that is not a partnership. What is that? A charitable business. It's still legal. Please understand, I'm not saying you may not do it. It's still legal, but it's not a partnership. Purpose of making a profit, personal benefit, your own back pocket, not to give to somebody else. But important here, it must be capable of making a profit. But it is not a requirement that profit should actually be made. What do I mean by this? And I've always found this very odd. Students interpret this, that I give them a case study about people that were in a partnership. Very now, Nathan and Helene were in a partnership. And now business goes pear-shaped. Things go wrong. That happens. That's an economic reality. They end up making a huge loss and owing Victor a stash of. And now students will tell me, but it wasn't a partnership because they didn't make a profit. No, 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 no. It was a partnership. It was capable, if things worked out right, to make a partnership. The fact that they ended up a loss doesn't suddenly mean that it wasn't a partnership. Because the intention was there to make a profit to start off with. That is important. It is not a requirement profit actually you. If you make a loss, sad for you, but it stays a partnership. Profit must be shared. Does not have to be shared equally. So if Shikupe, Sophia, and Nathan decided that Sophia would get 80% of the profits and Shikupe and Nathan 10% each, don't tell me that's unfair. They agreed. They agreed. So you can't say it's unfair. If they weren't happy with it, into this partnership. It is not a requirement that they must each get an equal share. The ratio can be freely decided upon. The ratio can be freely decided upon between the partners. whatever they decide goes. It also doesn't even have to be a percentage. There can be an agreement that partner one will get the first $100,000 and the rest will be shared. And then if they make less than $100,000, the others don't get anything. But each partner have the potential, depending on the success of the business, to share. So each partner must at least have the potential, the hope of sharing. Okay. Any questions? Okay, Benjamin is happy. I'm going to stop here for today. Let this all sink in. Might be a little bit overwhelming for now, but that's fine. As we go on, we keep on coming back to this because, as I said, starting, Benjamin, your hand is up.
Morning, madam.
Yes, Benjamin.
Yes, no, I thought you have given us a chance to give now the general questions. It's not about what we did today. This is actually about the test that we are going to have. You say it will be on the 6th, right?
I don't have the course outline in front of me, but I think so.
Okay. Yeah, I think I have also seen my course. Yeah, I think it will be on the 6th. Okay. I would just like to know the units that are going to be covered in this test.
No, no, no. Sorry, Benjamin, you're wrong. You're wrong. You're wrong. It's not
Mm,
on the 6th.
it's
It's on the 3rd. It's this coming Saturday. I have the course outline open in front of me on my
on
laptop now.
the
It's
third.
this coming Saturday, the 3rd of May.
Okay, okay.
So if
Thanks.
it's on the 6th, that could be a problem. The
Yeah.
6th is a Tuesday. I won't give you a test on a random Tuesday. It's this coming
Oh,
Saturday.
yeah. I think I didn't eat. I checked my. So I haven't checked it now. So I think I have forgotten.
Okay. No, but that's fine.
The
It's on. You wanted to know
okay.
what units it covers? It will
Yeah.
cover lease because your first test covered contracts and purchase. This test covers lease agreements, agency, and unit 12, this first unit of partnerships.
The bad. Okay.
So
You need to.
units 10, 11, 10, 11, yeah, 10, 11, and 12 only.
Okay. You need this partnership is 12. Only these three.
Yes,
Okay.
only those 3 units. So it's going to be easy peasy as pie.
Okay, man. Yeah, but yeah, it's not easy, man. The way the questions actually come in the tests.
Okay, just remember, Benjamin, this is an online test. So the
Mm.
type of questions will be slightly different from what you will be expecting in a face-to-face test,
Oh,
in the sense that um, there's no case studies where you have to type out an answer.
oh, okay.
In all, it's not just multiple choice, but it's multiple choice, true choice, true and false, select the correct word or correct answer from drop down menu, etc., etc., etc. Plus, it is open book. You have your notes with you. So
Yes,
I'm
madam.
expecting very good results from all of you.
Okay, madam. We'll do that. Okay. Thanks,
Lovely.
ma'am.
Okay. Okay,
Thanks.
so I'm going to stop here. Just back to partnerships quickly. It might have been a little bit sort of disjointed and confusing still this morning. As explained, there's a lot of repetition. This morning I gave you some backbones, but get back to this and referring back to this and adding more and more detail. It all fits together very nicely at the end of the day. Thank you for having made the time to end this class. It is much appreciated. Um, I will see you then Monday evening at 8 o'clock. Thank you. Bye.